So, a very good afternoon to all of you, all the people who are part of this seminar being organized. Uh, uh, as we all of know that today's seminar, in fact, 2 days seminar, which is going to conclude tomorrow, we are here to discuss about the major amendments which have been done in the criminal laws. So, I think most of the technicalities of the issue, all the changes which have been there, the legal provisions, amendments, numbering data, I think they have already been being shared. And if not, definitely they are going to be shared with you by the coming speakers. But I am not going to talk about what which has been there. I would rather focus on the thing that do we really need to have these kind of changes. So that is the theme of my speech, I can say, and that is going to be elaborated further. So the first thing, again, I am repeating that do we really need the kind of exercise which has been done by the government, and of course Parliament, as because Parliament has passed it. And secondly, if yes, if the answer is yes, that definitely we need this kind of exercise because we get to rid from the colonial era of mindset and all those kind of things. Then again, my second question would be that even if that is the answer to the question that is there any need, then did we really did that much of exercise to answer that question? Do we really need? And if yes, have we done that exercise? And is the outcome of that exercise is of that kind that we can justify the changes which have been done? And why I am saying so, it is not because that whenever you got to speak in these kind of seminars and conferences, some of the people, they are in favor of this, some of the people, they would be against this, and there might be a balance of opinion also. So of course that is a matter of perception for the people to decide. But the reason which I suppose because of which I am not, although again I am repeating, and you may consider it as a disclaimer, I am not against whatever which has been done regarding the amendment of criminal laws. That is the first disclaimer which I want to quote. I am not against whatever which has been done. But my concern is the way it has been done. Can we justify that? Or do we really need to have the things in this manner? First of all, when we say that these criminal laws amendments, they were required and all that, the basic simple question which comes into the mind is that did we really changed the law? Although this would have been done by the amendment also, but still since they have the whole new law is there. So my question is, did we really change or did we really reform the old colonial law? When you see the data, I'm not going to that much detail of the data, but simply speaking, we can say that 90 to 95% of the law in all these.
All the participants are requested to kindly mute themselves. Disturbance in the seminar. Kindly mute yourselves.
Why I am saying so, again, I am repeating because of some disturbances that uh, how much change, if you talk about which has been done, it is not more than 8 to 10% change in the provisions of the law.
Just give me a minute. Let me mute everyone.
Yeah, sure, please.
Yes, sir. You may continue, sir.
Okay, yeah. So the my question is that when you see the overall three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, एवं भारतीय साक्ष्य संहिता, not more than 8 to 10% changes have been done. So my question again remains the same, that if we really need to overhaul the laws and to get away with this colonial mindset of laws and the legislation, then is this exercise which has been done for, I think, from in the year 2020, I think a commission was set up under the chairmanship of Professor Ranveer Singh. So in these 4 years, uh, we did changes. Of course, they are being seen also, but how much? Not more than even 10% of the changes if you talk about, whether you talk about IPC, CRPC, or evidence. So if we really need to have the changes, then I think much of the exercise which was required to be done, it has not been done according to me. Means something more could have been done if you are completely changing the law. I can justify what I am saying, and which is, of course, I will quote Justice Honorable Justice Madan Lockwood sir also, because I also heard from him somewhere. When you see the illustrations like the women quick of child in old IPC, when you see the BNS, you again see the same kind of language and the same kind of illustration. Now, how many of you have heard the word women quick of child? If you talk about the reforms, shouldn't we do with these kind of words, women quick of a child? Do we really use this kind of words? One more example, which was there in the old IPC, uh, where whenever any person who falls on the ground while doing horse riding, the surgeon who is doing his skull surgery, if he is using that surgical instrument, trippin, then he is going to be punished for that. Now, don't you think that this kind of illustration is still required in 2025? Is it required at all? How many of the people nowadays they do horse riding? How many of people while doing the horse riding they fall away? And how many of whom they have fallen down? They need to have surgical operation, and the doctor who is doing the surgical operation, he is using weapon, that is a surgical instrument. Now, this kind of small illustrations, they clearly indicates one thing, that most of the part it has been as it was there in the earlier version of criminal laws. Because I think if these kind of illustrations of 1860 are still there in 2025, then I don't think there is much use of doing this kind of exercise. Now, coming to the next part, when you say that we are earlier it was IPC, that is Bharatiya Dand Sanhita, that we are punishing a person, and that is why the word was used. Indian Penal Code, where the people used to be penalized, they used to be punished. Now we are saying Bharatiya Nyaya Sanhita. So wouldn't you agree with me that since crime is considered to be done against the society, and if somebody is punished for the crime, obviously and automatically we are providing justice not to the victim and his family, but to whole of the society by and large. So again, the question remains the same, that merely changing the name from Bharatiya Dand Sanhita to Bharatiya Nyaya Sanhita, will it serve the real purpose? Because the justice was already being there. When you punish a person, when you punish a criminal, obviously you are, why you are punishing him? Because you want to deliver justice to the people, to the society. So merely replacing a word justice with the word penal, I don't think that it would be of much helpful in the context of judicial reforms. Again, coming to the next point,
So your video and audio is not visible. Uh, Ratan sir, I think he's been disconnected somehow.
नो मैम म्यूट कर दिया सर
I think now it is audible.
Yes,
यस
sir.
सर
Yes, sir.
Yeah. Okay. So now coming to the next part, that we are using the word Indian. These acts of 1860, they were passed in the British era, and since they were for India, they were using the word Indian, and that is why we use the word Indian Penal Code or Indian Contract Act, Indian Partnership Act of 1920, 1930, whatever. But now, post independence, do means just forget about these three laws. Uh, do you need to use the word Indian before the Indian laws? For the simple reason that we, the people of India, we have sent our representatives in the parliament. They are also Indians, and they are making laws. Indians are making laws for India, and obviously it means what? That all these laws, they are made by the sovereign power of India, authority derived from the constitution, and that is for the people of the country. Have you ever heard, just for take very small example, Biodiversity Act? So do you need to uh, prefix a word Indian Biodiversity Act, or is that Indian word part of that Biodiversity Act? Or when you talk about IBC, that is not Indian, that is Insolvency Bankruptcy Code. So are we going to say Indian Insolvency Bankruptcy Code? So the point is that as such, there is no need to prefix the word Indian. It is quite obvious. It is implied. It is quite understandable that all these laws, They are for the Indians. They are made by Indians. So why we are saying Indian, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Sanhita, like that? Why we are saying so? And if at all we have to use the word Indian, then it shall be for all the laws which are being passed by the parliament. So again, that is means I am putting this all these questions in a debate. Let this house discuss on the few coming speakers. They should discuss on this thing, and then we can have our open session also. So whatever which is in my mind, I am just sharing those thoughts with you. Then we have also seen uh, the fate of these kind of amendments. Again, very simple example you can take, that is of Companies Act 1956. A lot of talks were there that companies, they are not able to work in India. There is no ease of doing the business here. It is very difficult to get the registration here. Laws are very complicated. They are so vast, very complex net of laws, and all these kind of things we used to hear. And that was, I think, the background which was required to be prepared, or the homework which was required to be done for having the new law. And what was the result? Now we have Companies Act 2013. So do you really think that there is any change in the corporate sector merely by having the Companies Act of 2013, a new act being replaced by the old one of 1956? So again, the point is, do these kind of things really work? Because again, when you see the Companies Act, uh, a lot of discussions were there, and there was a talk that we should have a very small, simple, precise, to the point Companies Act. But just see the Companies Act, how many sections are still there? And the same fate, I think, we have seen for the criminal laws also. Because when you cannot change more than 10%, you cannot say, means rather we shouldn't use the word that we have reformed the law. I think we haven't. So these are the few of the important things which are there in my mind. With example also, I have shared these kind of things. And one more thing which is there in my mind, because whenever you talk about reforms, reforms are made to simplify the things. If you talk about the judicial system, then you should mean we need those kind of reforms which speed up the process of the things. We are already having so much pendants in the courts and all that. But what has happened because of this? I think many of us, they don't know and might be knowing, but obviously nobody can do anything for that. That all the crimes, offenses which have been committed prior to July 1, 2024, all those offenses, they will be still being governed under old IPC. All the offenses and crimes post July 1, 2024, Bharatiya Nyaya Sanhita, that will be there as a substantive law. So now see the practical aspect of that in the courts. As a lawyer, what will be there in your mind? If I am a practicing advocate, and if I have the cases registered prior to July 1st, 2024, I will have to prepare myself for the old IPC. Then those cases which now I have taken post July 1, 2024, I should be well versed with the new BNS also. At the same time, the same thing happens for the judiciary also, judges, police, all the stakeholders. And this thing is going to continue, not for few years, but I think decades will be spent, because we know that 10 years, 15 years, 20 years, 25 years, 30 years, That much time, that is quite usual, which is being taken to deliver the justice in the criminal law system, and same for the civil also. So I think for coming few decades, although we have done the reforms, but these kind of things where old IPC will be there and the BNS will be there, both the substantive laws, they will be there for coming, again I am repeating, not for few years, but for coming decades. So I think that is one of the biggest, what I won't use the word drawback rather, but I think that will be again a thing which is has to be given a due regard, if at all we have some discussion of this kind in coming future. So these are the things which I need to share with you. And lastly, I would like to conclude that all these changes which have been there by having the new law, uh, I think it is old wine in the new bottle. And even if all these, even if it is 8%, 10%, or for that matter, 15%, 20%, whatever the figure is, even if at all these changes were required to be done, my opinion is that they would have been done merely by having amendment in the existing laws. So, as such, there was no need, according to me, again, I am repeating, to have change in the name of the law on the name of just having 8, 10, 20% changes in the existing provisions. And somewhere I was reading that in, I think in Evidence Act, only one new section has been incorporated. In CRPC, only 7 new sections have been incorporated like that. If that is the exercise which has been done, for God's sake, I don't think that this kind of exercise we really need to have in future. So all these amendments, according to me, they should have been the part of IPC. And secondly, in criminal system, I think there should be a consolidation of laws so that all the minor criminal laws, so many like Mokoka and state laws and all that, or drugs laws, or trafficking laws and all that. I think whatever the law which is criminal by nature, according to me, that should be the part of one major criminal law. And if now we are having BNS, all these laws, they should be part of one major laws. Means chapters can be added, of course sections can be added, but I think when you talk about the consolidation should be done in such a manner that, because what is happening now, that there is a ocean of laws. Many times even the judges, they don't know that there is a law on this particular area of criminal matter, or even advocates are not aware about that, just forget about the professors and the students of the universities. So I think when you talk about the consolidation, these all these things, they should be part of only one criminal law. And I think that would be my suggestion for this seminar, that whenever we do this kind of exercise, we should have one single uniform law where all the criminal minor acts, the examples I already gave, they should be part of the same legislation. And since I am the person from financial law, I can quote you example also that in financial sector, I think there are more than 64 or 67 financial sector laws, ocean of laws. They are scattered at several places, and that is why the government, I think in 2011 or 2009, a commission was being set up by the government under Justice Sri Krishna, and that Sri Krishna Commission, they also gave the report, and they also said that, and they also quoted the example, and they said that we should have one single uniform law, that is IFC, Indian Financial Laws. So I think whether you talk about the financial sector, financial laws, or the criminal law, whatever, means there should be a consolidation of laws, and all the laws should be at some common point, so that common man and of course all the stakeholders, they should completely well aware what are the laws and where they are going to find in those laws. So that's all from my side. And lastly, I would like to end this discussion. Rather, I won't say that it is a speech. Rather, I would say that it is a discussion on my part. I have given you several points which can be discussed in the coming sessions of this seminar. And to quote Professor Upendra Bakshi, uh, rather than we go for the changes in law, which we already did, we should go for the overhaul of judicial system. And I think he has very rightly quoted this thing, because as such, when you only talk about 8 to 10% changes and 92% things they are same, then I think there is a default in your system and not in the law. So that is why at this juncture, our focus should be on the overall changes, overhauling of the judicial system, but not the law. Thank you so much.
Thank you so much, sir. Thank you so
Well,
much for your insights.
welcome.
Thank you so much for the valuable time that you've spared with us today.
Thank you.
If any participant has any question, sir would be kind enough to answer.
Sir, when we have said that there are 8 to 10% of changes in the new law,
Mhm.
and it could have been amended. So, can this be considered to be a classic case of ultra virus act from the legislative part? There have been challenges that were being made in the court of laws as well, different honorable courts, high courts, and Supreme Court, but the judiciary has not stepped in. So, how will we analyze whether there is any law which mandates that there should be a certain percentage of change when we want to completely reframe the law?
Uh, I think that there cannot be a law to address each and everything, because if we go in that much of the things, then it would be rather more complicated. Means what I understood, what I got from your question is that we should also have the law which fixes the percentage of the changes. I think that is what you were talking about. Am I right?
Yes, to bifurcate whether there has to be an amendment or a complete new law. Yes.
No, I think the procedure is very clear, or the system is very clear, that the whole power to do this exercise lies with the government, and obviously the government means what, the party which is having the majority in the parliament. So I think when any party which is having the mandate in the parliament, they have the power to do so. But whether it is useful, it is beneficial, it is fruitful, that will be decided by the time. With the passage of time, only we can say that whether it was a good move or not. But I think, according to me, we cannot have means when we are discussing about the new law, means which according to us it should not have been. Then there is no point of saying that we should have that kind of law which should fix a cap on the percentage of the things. I think that can means I think that is not practical to do so.
Understood. Thank you.
Welcome.